Hello friends, welcome to our channel. So today we are going to discuss about the two case laws which has compelled the government to make changes in the law for the protection of women. So first we will discuss about Mathura Rape Case. What happened in this case, Mathura, a girl of around 16 years of age, was living in Desai Ganj, Maharashtra along with her brother, where both of them were working as a laborer. Mathura, while working as a laborer at the house of Nunshi, developed feeling for her brother Ashok, and both of them decided to get married. What transpired is Ganpat, a brother of Mathura, lodged a complaint against Ashok, Nunshi and Nunshi's husband for the kidnapping of Mathura, subsequent to which all of them had recorded their statement at the police station around 10:30 p.m. at night, after which the police Subsequent to this, the police officer told all of them to leave the police station except Mathura. After some time, when Mathura did not appear out of the police station, Mathura's brother Ganpat, Ashok, Nunshi, and Nunshi's husband got suspicious and they started looking for her. Hearing their voices, villagers also came outside and started looking for Mathura. Hearing their voices and uproar outside the police station, Tukaram came outside, claiming that Mathura had already left. But she emerged from behind the building, sobbing, and said she had been raped. Mathura said that Ganpat took her to a lavatory at the rear of the main building, loosened her undergarments, lit a torch, and stared at her private parts. Then he pushed her to the ground and raped her. Mathura said, "गणपत ने इज्जत लूटी, मुंह दबा दिया था, तुकाराम ने छूकर बोला अच्छी है." And after this, an FIR was registered against the accused Ganpat and Tukaram, and the Mathuras had been taken for medical examination at Chandrapur district, which is located 140 km from Desaiganj. At the end of a 4-hour journey, she was later subjected to another cruel practice of two-finger test to determine her virginity. Dr. Kamal Shastrakar examined her almost 24 hours of the incident and said that there was no injury on her body, although her hymen revealed old ruptures and the vagina admitted two fingers easily. When the matter reached the Session Court made certain shocking observations. First of being that the testimonies of Mathura is riddled with falsehood and probabilities, and the Mathura is a shock liar. The court further observed that Mathura, while finding Nunshi angry and knowing that Nunshi would suspect something fishy, Mathura, could not have very well admitted that she had sexual intercourse out of her own consent, out of her own free will, and she had surrendered her body to a police constable. She rather said that she had been raped. On the issue whether Mathura was below the age of 16 years at the point of occurrence of incident, the court observed that there was no satisfactory evidence to prove that Mathura was below 16 years of age on the date of occurrence of an offence. Court further observed that Mathura is habituated to sexual intercourse, which is clear from the testimony of Dr. Shastrakar, and it can also be a possibility that the seminal stains on Mathura can be from the sexual intercourse with another person other than police constable, and on this ground, Session Court acquitted both of the accused. Another observation which court made is there is a difference between the sexual intercourse and rape, and the most one can conclude in the present case is there has been a sexual intercourse between police constable and Mathura. On this ground, the Session Court acquitted both of the accused. The matter later on court, when the matter reached the High Court overruled the judgment of Session Court and convicted the accused. The court observed that the mere passive or helpless surrender of a woman to the threat or lust induced by fear cannot be equated with the desire or will of the woman on the sexual intercourse and between the man and woman, and the mere fact that the sexual act was not in opposition to such desire or volition cannot be said to be consensual sexual intercourse. On this ground, the High Court convicted accused. The matter reached the Supreme Court. Supreme Court, on the similar line of reasoning as was given by the Session Court, acquitted both of the accused. The court further observed that the act of Mathura of not crying out for help even before and her failure to appeal for companions who were no other than her brother, her aunt, and her lover, and her conduct in meekly following Ganpat shows her willingness rather than her passive submission to their authority and power. And on this ground, the Supreme Court acquitted both of the accused. After this judgment, a lot of hue and cry was there in society, and many academicians, jurors, and lawyers wrote to the government criticizing the judgment and demanding the amendment in the criminal law for the protection of women. Let's discuss the Criminal Law Amendment Act 1983. The first amendment that has been done in the Criminal Amendment Act is the addition of Section 376B in the Indian Penal Code. This section punishes the intercourse by public servant with a woman in his custody and can be punishable to an extent of 5 years, and person shall also be liable to fine. Second important amendment is the addition of Section 228A. I personally consider this amendment as one of the important amendments being done by the Criminal Law Amendment Act 1983, because in our society often stigmatize a victim for offense of rape. So this Section 228A punishes a person for disclosure of identity of the victim of rape. This section is added to safeguard the rights of a woman. Another important section is the addition of Section 114A in the Indian Evidence Act regarding the presumption as to absence of consent. Once it is proved in a prosecution for offense for rape that the sexual intercourse is done by the accused, and the question is whether the sexual intercourse or the sexual relationship was with or without the consent of the woman. If the woman says that state or an evidence court that she did not consented to having such sexual relationship, then the court shall presume that she did not consented to having a sexual intercourse or any sexual relationship with that person, and it is incumbent upon the person accused to prove that the woman had consented to having the sexual intercourse, shifting the onus of proof from victim to the accused. Now let's discuss the second case law, Nirbhaya Rape Case. What happened in this case is, on the dark and cold night of 16 December 2012, a 23-year-old physiotherapy trainee was brutally assaulted and raped in a moving bus in South Delhi by 6 accused: Mukesh Singh, Vinay Sharma, Pawan Gupta, Akshay Thakur, Ram Singh, and a juvenile. The Supreme Court in this case found all of the accused guilty for an offense of gang rape, unnatural sexual act, murder, criminal conspiracy, assault, and criminal intimidation. One of the accused, Ram Singh, committed suicide in Tihar jail on 11th March 2013, and the other accused juvenile was released after serving 3-year term at a correction home. As the news of the rape spread, the outrage from different fractions of society erupted, leading to the formulation of Justice Verma Committee and Usha Mehra Committee. Following the report submitted by Justice Verma Committee, the Criminal Law Amendment Act 2013 was passed, making changes in the substantive and procedural law. Now, let's discuss the changes introduced by the Criminal Law Amendment Act 2013. First, we will discuss about the amendment in IPC. The Criminal Law Amendment Act 2013 widens the definition of rape under Section 375 of IPC. Now, the Section 375 of IPC is not only limited to penile vaginal penetration, will also apply in the cases where the penis is in urethra, vein, vagina, mouth, or anus, and also includes acts where a man applies mouth in an organ like vagina, urethra, and anus of a woman. Person is held liable of doing any such act, then the man will be punished for an offense of rape. Another important amendment is the addition of Section 166A of IPC. Under this section, public servant will be under obligation to record information given of the commission of an offense of rape, and if public servant refuses to do so, then he or she can be made punishable under Section 166A of IPC. We have already learned in the case of Mathura that the police officer was reluctant to register an FIR and to conduct an investigation against police constable. By this amendment, such an act will be reduced to some extent. Now, let's come to Section 166B of IPC. For this section is very important because prior to this amendment, what happened is sometimes hospitals refuse to treat a victim of an offense of rape. Hospitals will be under an obligation to treat the victim of rape, and if they refuse to treat the victim of rape, then the hospital authorities will be made punishable under Section 166B of IP. Another important addition is the offense of sexual harassment, voyeurism, disrobing, and stalking. Now let's discuss first sexual harassment. This section is inclusive and acts like making physical contact, demanding sexual favors, and showing pornography to a woman by a man as punishable under this section for a rigorous imprisonment which may extend to 3 years. This section also covers the offense of making sexually colored remarks to a woman, for which the imprisonment may be extended to 1 year. Now let's discuss Section 354B. Section 354B punishes the assault or criminal force with intent to disrobe a woman with an imprisonment of up to 3 years, which may extend up to 7 years and a fine. Another important amendment is definition of voyeurism. Under Section 354C, voyeurism has been defined as an act of gaining pleasure from watching others naked or engaged in sexual activity. If any person is found guilty of making such an act committed by a man, then a man will be made punishable with 1 year imprisonment, which may extend up to 3 years. If a man is convicted of such offense more than once, he or she will be punishable. Then he will be punishable with a minimum of 3 years of imprisonment, which may extend to 7 years. The stalking is defined under Section 354D as the act of following or attempting to make contact with a woman who had already shown disinterest in a man, or monitoring her use of social media for email or other electronic communication means is made punishable under this section for up to 3 years, and for the repeated offenders, punishment will be imprisonment, which may extend up to 3 years and fine. Another important section is the deletion of Section 376(1) and 376 Clause 1 and 376 Clause 2. This section allowed the courts to reduce the sentence for an adequate and special reason to be mentioned in the judgment. Now the courts will have no discretion to reduce the sentence for an offense of rape committed by a man against a woman. Let's discuss the amendment made in CRPC by the Criminal Law Amendment Act. The first amendment is made under Section 154 and Section 161 of CRPC. Section 164 provides that if the victim is mentally or physically disabled, then the recording of statement should be done at their residence or any other convenient place in the presence of interpreter, and the recording should be videotaped. And in Section 164, a provision is added for the assistance of an interpreter or special educator and videography of the statement. Moreover, this is also held that the statement under Section 164 will be considered as a statement in lieu of examination of chief, and that can be cross-examined at the time of trial. Section 273 was also amended and includes a provision which requires the court to take appropriate measures so that the woman under age of 16 years and victim of rape or sexual offense should not be confronted by the accused, while also assuring the right of cross-examination of accused at the same time. Section 357C, it is made the duty of the hospital to provide treatment free of cost to the victim of sexual offenses and to inform the case to the police authorities immediately. Section 196 and Section 197 has been added by this amendment, and in this explanation, it is provided that in case of sexual offenses, no previous sanctions is required to be taken from the respective government for the prosecution of public servant, magistrates, and judges. Section 309 is also amended, and in the Clause 1 provides that all the proceedings relating to inquiry or trial sexual offences shall be done within a period of 2 months from the date of charge sheet. Now let's discuss the amendment made in the Indian Evidence Act by the Criminal Law Amendment Act 2000. Section 53A was added in this act, which declares that during a prosecution for actual or sexual offense, the character of the person or previous sexual experience of the victim is irrelevant as to evidence of the consent or quality of the consent of the victim. We have previously discussed in the case of Mathura that the Session Court took into consideration. We had already discussed in the case of Mathura that the Session Court, while acquitting both the accused, made an observation regarding the character of Mathura and her sexual experience as an evidence for the consent and the quality of the consent of the victim. Now, this kind of statement will be made irrelevant under Section 53A of evidence. It will not be admissible in the court. Another important amendment is the Section 114A, which states that it was sufficient for the victim of sexual offences to state before the court in her evidence that she had not consented to the sexual intercourse so as to presume the absence of consent in the case. Now let's discuss another addition. Section 146 of the Act was amended to include the provision which state that no question can be asked from the victim of sexual offense during cross-examination which are immoral in nature or which are related to previous sexual experience of the victim so as to prove the consent or test the quality of the consent by the victim.